Hello, my name is Ellen Schwartz, and I'm the Director of Legal Resources for the Middlesex County Family Justice Center, a part of Women Aware. This law video series project is co-sponsored by the New Jersey State Bar Foundation and made possible through funding from the IOLTA Fund of the Bar of New Jersey.
Hello, my name is Malia Janjua. I'm the Director of Client Services at Women Aware, and we will be discussing child custody today. Hi, Ellen.
Hi.
How does custody of children work in a domestic violence situation?
Custody of children is governed by statute in New Jersey. In a situation involving domestic violence, whether it's just alleged or it's proven, it is the victim who will usually be awarded custody, not the abuser, at least on a temporary basis. The situation may change at final hearing depending on the testimony of the parties or what they might agree to. The most important consideration for the court is always the best interest of the child.
Are there general rules regarding child custody?
Yes. Whether or not a domestic violence situation exists, there are a few general provisions regarding custody. The first one is the rights of both parents are presumed to be equal. Neither parent has an automatic advantage because of their gender. Second piece is the language surrounding custody can be confusing. Joint custody has two components. The first one is physical custody, where is the child going to live the majority of the time? And the second part is legal custody, which involves consultation between the parents involving major decisions about the health, welfare, and education of the child. Sole custody means that one parent is the decision maker and handles all the day-to-day issues for the child, and the other parent has parenting time.
What does a judge consider when making a custody determination?
That's a great question. There are certain factors that a judge has to consider, and those are set out in the statute. So some of those factors include the party's ability to communicate and cooperate, a history of unwillingness to allow parenting time, in other words, if one party is withholding the child from the other party, the relationship of a child with its parents and siblings, the safety of the child and the safety of the parent from physical abuse by the other parent, the preference of the child when the child is old enough and has the capacity to make a decision and articulate that decision, the needs of the child, the stability of the home environment, the quality and continuity of the child's education, the fitness of the parties, the geographical proximity of the parties' homes, the parents' employment responsibilities, and the age and number of the children. There are other things that a judge may consider which either party can bring to the judge's attention during a hearing.
What if we don't want a custody hearing? Can the other parent and I agree on custody and parenting time?
The short answer is that the parties know best their own individual situations. They certainly know better than a judge, and they know what's best for their children. So if the parties can agree on custody and on parenting time, a judge is only too happy to avoid a trial and having to make those decisions. So if the parties do reach an agreement, it should be in writing in as much detail as possible. It should cover things like where will the children live most of the time, where will they go to school, when will they see the non-custodial parent, how will holidays be shared, how will pick-up and drop-off be handled, and a host of other things. If the parties are going to use terms like joint custody, legal custody, or residential custody, they should both have a clear understanding of what those terms mean. Sometimes it's a good idea to actually include the explanations or the definitions in the agreement. If the parties are unable to agree on a custodial arrangement, the court might require each parent to submit a parenting plan setting out specifically how they would handle custodial responsibilities. It's important to know that the court provides free custody and parenting time mediation for all contested custody cases. So if someone files for custody, the case will be assigned to a mediator. Both parties will need to come to court, sit down with a mediator, and try to work out a custody arrangement. The mediator helps the parties. The mediator does not make decisions regarding custody and parenting time. Only a judge can do that. If the parties agree on everything, the mediator will write up an agreement, both parties can sign it, and it becomes a binding order when the judge signs it as well. It's important to know that custody and parenting time are always subject to review by the court. In other words, things happen. Children get older, they have their own schedules and activities. Someone might move away, someone might become ill and be unable to care for their child. Either party has a right to come into court at any time up until the child is 18, seeking to modify the custody and parenting time arrangement if they feel it's in the child's best interests.
What if I want to relocate out of New Jersey with my child?
Relocation is a bit of a difficult issue. It can be tricky. So a parent can relocate with their child in one of two ways. One party must have the consent of the other party, preferably in writing. And if the other party isn't willing to consent, the parent seeking to move will have to file an application with the court asking for permission to relocate with the child. So the court will look at all kinds of things, including, does the parent have a legitimate reason for the move, like a marriage or a new job or a better support system? What arrangements will be made for the other parent to have time with the child? And finally, can the parent that seeks to move be trusted to encourage the relationship with the other parent?
Thank you, Ellen. Now I will discuss domestic violence and child custody. Abusers will use the court system to continue to harass and maintain control of their victim. Many times a victim decides to stay in an abusive relationship due to the children and being there for the children as a means of safety. At Women Aware, we are here to provide you with the support, information, referrals, and safety planning. We have our Middlesex County Family Justice Center. We have partners that we work with in the center. We have our PALS program. Our PALS program is a trauma reduction program for children between the ages of 3 and 12 who have witnessed and been affected by domestic violence. If you do need our support, we are here for you. Thank you for joining us today.